Picture the American legal system like this massive, ever-expanding universe. You've got these huge gravitational constants, our constitutional rights established by the U.S. Supreme Court. But right now, those federal constants are on a literal collision course with a totally new, rapid-fire force state legislation out of Colorado. Welcome to This Explainer. Today, we're diving straight into this crazy legal friction point where sweeping new state gun control mandates are slamming right into the immovable object of federal Second Amendment precedent. All right, here's our roadmap for the day. First, we'll hit the common use doctrine. Then, it's a tale of two tests. After that, we'll break down the new Colorado mandates, look closely at Del Toro v. Polis, and wrap up with some updates on current litigation. So, part one, the common use doctrine. To really grasp this collision, we need to start with the baseline the Supreme Court laid out. It really all hinges on this idea of common use. You guys probably know this stems from the landmark Heller decision. Basically, the doctrine says the Second Amendment protects weapons typically possessed by law-abiding citizens for lawful purposes today. The focus is completely on what everyday Americans commonly own right now, rather than strictly what existed, say, back in the 1700s. And lower federal courts have really flushed this out. Just look at this quote from the D.C. Circuit Court of Appeals and Heller 2. They flat out said, "We think it clear enough in the record that semi-automatic rifles and magazines holding more than 10 rounds are indeed in common use." That phrasing right there is absolutely crucial. It's the core argument for gun rights advocates. Because semi-automatic firearms and standard capacity magazines are so wildly popular, they sit firmly within the protective orbit of the Second Amendment. Moving on to part two, a tale of two tests. This is where we zoom in on the structural conflict of this whole explainer. We've basically got two entirely different legal gravity wells fighting for control. Okay, look at how these stack up. On the left, there's the U.S. Supreme Court standard recently cemented in the Bruen decision. This is a strict history-only standard. If the Second Amendment covers your conduct, the government has to prove their regulation is consistent with the nation's historical tradition of firearm regulation. No modern interest balancing allowed, period. But over on the right, we have the Colorado State Court standard. They use the reasonable exercise test. This framework actually validates regulations serving legitimate public safety purposes as long as they don't completely nullify your core right to self-defense. This really gives us a great look into the state's logic. Under this reasonable exercise test, which traces back to the Robertson v. Denver case, Colorado courts argue that laws, like magazine capacity limits, are constitutional. They're thinking, well, if you still have hundreds of other ways to bear arms for self-defense, restricting one specific magazine size or weapon type doesn't erase your core constitutional right. You can see how that's a completely different foundational logic from the Supreme Court's strict history test. All right, part three, the new Colorado mandates. Let's take these abstract constitutional theories and see what happens when they hit physical, unstoppable state legislation. Enter Senate Bill 25-003. Signed into law in early 2025, this thing is huge, and its main provisions kick into full gear by August 1, 2026. It effectively bans the manufacture, distribution, sale, and purchase of a massive array of semi-automatic firearms. That is, unless you meet some incredibly specific, newly legislated exceptions. And navigating those exceptions, it is no joke. You have to jump through this strict permit-to-purchase scheme. Step 1, you have to pay out of pocket for a third-party background check. Step 2, take those results, apply to your local sheriff for an eligibility card, and pay processing fees. And honestly, that just gets your foot in the door. Because for Step 3, you have to complete mandatory extended safety courses and pass a written exam. Oh, and you have to score at least a 90% on that exam just to be eligible to buy a specified semi-automatic firearm. But wait, there's more. On top of that rigorous permit system, SB 25-003 reclassifies things it calls rapid-fire devices, which include certain trigger mechanisms, as dangerous weapons. Just possessing one of those is now a Class 5 felony in Colorado. These major changes on the ground are exactly what sparked the legal fireworks we're seeing right now. Which brings us to part 4, Del Toro v. Polis. Let's check out the actual impact crater of this constitutional collision with a major federal lawsuit. So this is the official civil complaint filed in the U.S. District Court in Colorado. A group of plaintiffs and advocacy groups are going right after SB 25-03. And the lead plaintiff here gives us a really profound, very human look at what happens when these two legal universes crash into each other. The lead plaintiff, Israel Del Toro, is a disabled Air Force veteran.
Back in 2005, an IED blast in Afghanistan left him with burns over 80% of his body. He lost one hand and most of the fingers on the other. According to the complaint, because of these severe physical restrictions, he relies entirely on AR platform pistols with stabilizing braces and specific force reset triggers just to physically operate a firearm for self-defense. The lawsuit argues that by banning these specific mechanisms and making them felonies, the state is effectively stripping his ability to defend himself, noting that the new law has absolutely zero accommodations for disabled folks.
And that very human element ties directly back into a strict constitutional argument. The plaintiffs are saying, hey, look at the Supreme Court's Bruen rulebook. There is absolutely no historical analog from the founding era for this kind of complex, fee-heavy permit-to-purchase scheme when it comes to commonly used firearms. Because of that, they argue, the state's mandates presumptively violate the Second Amendment. Finally, Part 5, Updates on Current Litigation. Let's zoom back out and see how the broader judicial system is actually handling these kinds of cases. We can trace this roller coaster by looking at an earlier law, SB 23169, which raised the gun purchase age to 21. It was signed in April 2023 and almost immediately blocked by a federal district court judge in August. That judge used the strict Bruen historical test and said the law failed. But then, in November 2024, the 10th Circuit Court of Appeals completely reversed it and let the law stand. So, how exactly did they justify that under Bruen? Well, the 10th Circuit essentially created a safe harbor. They ruled that an age requirement of 21 is just a non-discretionary condition or qualification on the commercial sale of arms. By framing it as a long-standing commercial regulation instead of a direct ban on possession, the appellate court applied a totally different legal rule to the exact same case. As you can probably guess, this back and forth is creating total chaos. Federal firearm licensees, FFLs, and everyday buyers are dealing with these piecemeal injunctions that sometimes only project the specific people named in a lawsuit rather than everyone across the board. Because of this absolute headache, advocates and House Republicans are pushing hard for the federal DOJ's Civil Rights Division to step in and review SB 25-003. Their goal is to get a unified, statewide, or even nationwide federal response, so we aren't just relying on this fragmented, case-by-case mess. Which brings us to our final point, and honestly, a huge question for you to chew on. In this rapidly expanding universe of American law, as the immovable object of federal history smashes into the unstoppable force of state legislation, which standard is ultimately going to establish the balance? Are we looking at the rigid historical tradition of Bruen, or Colorado's flexible, reasonable exercise test? The fallout from this collision is pretty much guaranteed to redefine constitutional rights for decades to come. Thanks so much for joining me for this explainer, and keep questioning the universe around you.